So I just want to hurry up and say all the sections of Kentucky's Bill of Rights because, you know, Julie Chancellor or some other people, if you say the idea first, then you're the one that actually got to teach other people, right? Which isn't true. And sometimes actually you have to say something out loud to yourself about like 15 to 20 times before you actually memorize the shit. So, Section 18 is imprisonment for debt is restricted. Section 19 was a little bit complicated because it had to do with coal extraction. Section 20, that was also confusing because there was a Tanner operation of restricted. Section 9 and Section 12 were confusing too, but I'm going to take a look at the in the Robert Ireland book more about those sections. So there's only 5 more, and then the 26, Section 26 is sort of the, I want to say it's the Bill of Rights supremacy law, but actually Section 15 is the supremacy clause. So it says laws to be suspended only by the General Assembly. So that gives the General Assembly the only governmental institution that can change any of the laws. Only the General Assembly can suspend the laws, can change them, just the General Assembly. So it's a supremacy clause for the General Assembly, and then there's the Bill of Rights supremacy clause, Section 26, and the Bill of Rights supremacy just says that the first 26 sections of Kentucky's Constitution overrides Kentucky's, the rest of the Constitution or America's Constitution or any local or otherwise any other constitutions out there. So they declare these first 25 sections the most important. So Section 21 is dissent in case of suicide or casualty. So the estate of such persons as shall destroy their own lives shall descend or vest in cases of natural death. And if any person shall be killed by casualty, there shall be no forfeiture by reason thereof. So this is saying if somebody kills themselves, then that means if they had died naturally, that's where I think it's 50-50, it goes to their kid or goes to their spouses. And if they kill themselves, then it doesn't change. Basically, if they would have died a natural death, that's how it's determined, if somebody kills themselves. Which is interesting. There's a Section 21 deals with suicides in Gallatin County, which is relevant considering in Gallatin County there's 3 suicides: Chris Kidman, Mia Knotts, John Booth, and that really traumatized like the whole community. I remember they were protesting the school system at the time, and I remember thinking it was ridiculous, but now I'm starting to see that it actually made a ton of sense. So yeah, that's Chris Kidman. I remember he said that he didn't like me. I remember he was like, I don't like you. I don't like you. And then I also remembered him, he was going to be like this big golf star, and then he was going to have a scholarship. He got in a wreck with his car, broke up with his girlfriend, and then he killed himself after that. So the car wreck, I mean, seriously, like how much fucking pressure if your parents are telling you what to do, the school system's telling you what to do, and then just one little fucking break in the road, all of a sudden all is lost, everything's broken for you. Fuck it, who gives a shit? There is no hope for me. Pow pow. It's bullshit. I hate that Hunter S. Thompson killed himself too. But in each one of those cases, Chris Kidman, Hunter S. Thompson, if they were Kentuckians at the time, then it would have been ruled as if they died like by a heart disease or so, and then their inheritance would be distributed, by law. So Section 22, standing armies restricted, military subordinate to civil, quartering soldiers are restricted. So again, we see another doubling down. There's several double downs. Quartering of soldiers you can have. That's both U.S. and Kentucky's Constitution. The imprisonment for debt, that's something that's only the Kentucky Constitution has. So if you're in fine and you have debts, you can't be put in prison because you're in debt. That's Section 18. They're going against one of your civil liberties if they do that. Cruel and unusual punishment that's prohibited. Excessive fine and bails, right to habeas corpus, right to bail. Speedy trial, double jeopardy, eminent domain. So all these are double down. They both are in the United States Bill of Rights and Kentucky's Bill of Rights. So again, you can't have no soldiers allowed to be quartered in your house. So they can't just come in your house and say, okay, we're staying here. No standing army shall in time of peace be maintained without the consent of the General Assembly, and the military shall in all cases and at all times be in strict subordination to the civil power, nor shall any soldier in time of peace be quartered in any house without the consent of the owner, nor in time of war except in a manner prescribed by law. So even we're in a war society right now. So even then, unless they say, well, only quartered soldiers if so and so happens, and nothing has been codified in the law like that. So no quartering of troops at all. They said that there's no standing army shall in time of peace be maintained without the consent of the General Assembly. So we have a standing army at Fort Knox and I think Fort Campbell, and then there's the Bluegrass Army Depot, and there's lots of actually military outfits throughout the state. It says that they can't be maintained unless with the consent of the General Assembly. So I wonder if Frankfort has given consent for all these, especially Fort Knox. It's a federal Army base. So do they give that right, or does the federal Army base have its own rules and laws on its own base? So once it's in your country, you pretty much are fucked. Once American embassy sets foot on your place, it'd be like Fort Sumter, right? And then it'll start a civil war. So yeah, I guess Fort Knox has its own federal laws. It's sort of like its own sovereign nation. So the military shall in all cases and all times be in strict subordination to the civilian power. So that means the General Assembly has rights to the entire borders of Kentucky. So it has rights to Fort Knox. I think that'll set up a Supreme Court case, but they have rights to all the jurisdiction of Kentucky. And so here it says no standing armies are allowed except for in times of war, which that could be a argument in the case of it right now. But if there was not war, then you're not allowed to have a standing army unless the General Assembly approves it. So no standing armies. That's Section 22. That's very anti-military industrial complex. No, we don't have to have a bunch of soldiers standing around waiting to fight somebody, okay? So Section 23, no office of nobility or hereditary distinction or for longer than a year of terms. The General Assembly shall not grant any title of nobility or hereditary distinction, nor create any office, the appointment of which shall be for a longer time than a term of years. So I guess they're saying they're being careful with their lifetime appointments. They don't want a king or queen. They don't want a monarchy, so no hereditary distinction. Section 24, immigration to be free. Immigration from the state shall not be prohibited. So if you're a law-abiding citizen and you're not under trial or indictment for anything, you're allowed to leave Kentucky whenever you feel like it. You can just leave. That's Section 24. Section 25, slavery and involuntary servitude is forbidden. Slavery and involuntary servitude in this state are forbidden except as a punishment for crime whereof the parties shall have been duly convicted. So it's the new Jim Crow. Only if they can put you in jail, then they can make a slave out of you. If you are not put in prison, then they aren't able to make a slave out of you. And then Section 26, to guard against the transgression of the high powers which we have delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government and shall forever remain inviolate, and all laws contrary thereto, contrary to this Constitution, shall be void. So that's the first 20 sections of Kentucky's Constitution. The last one's no slavery. Slavery is illegal, so there's child slaves on farms, so that's Section 25. That was broken for 17 years of my life specifically, and lots of my cousins' lives. Immigration to be free. You're allowed to leave Kentucky whenever you feel like it. That's an expansion of liberty. No office of nobility. You don't have to say king or president, anything. Everybody's below the law. No standing armies, which is fascinating. Also, the military is subordinate to the civil, so you can't just have a rogue military force like the LMPD running around. They have to be subordinate to Mayor Fisher and the City Council, and if they're not subordinate to Mayor Fisher and the City Council, then they are an illegitimate organization, and they need to be dissolved and disbanded immediately. So that's all militia. That's the police forces and military outfits have to be, usually Fort Knox, they're like underneath the president and the Pentagon and Congress. But if they started going rogue and Congress had no control over it, then I would think that Kentucky, the governor of Kentucky, would have some rights to be able to stop some sort of, I'm just saying, like, there's been like a killing that happened at Fort Knox. Somebody just like goes in there and shoots somebody. So if one of the soldiers just goes nuts and starts taking a tank all over Kentucky, then they're just because they're the feds, it doesn't mean that they have rights above it. I think that the governor of Kentucky could organize a force to stop them in conjunction probably with everybody else, since most people would be on board with stopping sort of a rogue element of the military from happening. It also mentions the suicide thing. So there's 26 sections of Kentucky's Constitution. You should memorize every one of them and know them forwards and backwards. This was more of a discussion thing, but actually it's becoming more lecture-ish, but this is how we learn, right? And Section 9 of the Constitution was talking about truth may be given in evidence in prosecution for publishing matters proper for public information, jury to try law and facts and libel prosecutions. So this is about libel. You know, I'm thinking we got free speech. So Section 1 says you got free right to express your opinions, and then the Section 8 says all printing presses should be passed out to everybody. So everybody's allowed to have a blog in Kentucky that's legal. We have a right to freely speak and fully speak, write, print on any subject. As long as we're responsible for perhaps the abuse, and the abuse would be libel, which would be lies made about somebody's character or somebody's, there would be a lie. Libel is a lie about that person, and if people believe the lies, then that could hurt their reputation. So Section 9 is all about libel. It mentions libel. So truth may be given in evidence in prosecution for publishing matters proper for public information, jury to try law and facts and libel prosecutions, in prosecutions for the publication of papers investigating the official conduct of officers or men in public capacity, or where the matter published is proper for public information. The truth thereof may be given in evidence, and in all indictments for libel the jury shall have the right to determine the law and the facts under the direction of the court, as in other cases. In early American history, government could and occasionally did prosecute newspaper editors and publishers for the crime of seditious libel, which amounted to defaming or ridiculing the government, including its officers, and writing in a fashion that might undermine the public peace or public confidence in government leaders. Under English law, which theoretically applied in the colonies, the jury could only decide whether the defendant had published the allegedly libelous material and had to leave it to the judge to decide whether the material was libelous. The fact that a controversial statement was true did not constitute a defense, since the purposes of the law were to protect the security and reputation of the state and to punish public criticism of the government, no matter how truthful. However, in the seditious libel trial of Peter Zenger in 1735 in the colony of New York, the jury ignored the instructions of the judge and found the defendant not guilty, thereby creating a precedent for the proposition that the jury in such cases should decide whether the statement in question was libelous and considered truth as a defense. So in Peter Zenger's case, who was a German, right, Peter Zenger in New York in 1735, the colony of New York, there was a freedom of speech case, and the jury ignored the judge's instructions. They said, fuck you, judge, we're going to determine whether it was true or not. It was true. It's bullshit that you even fucking brought this shit. And the jury basically invalidated the judge's claims. And the jury has that power. So a lot of times the judge likes to manhandle them, get the prosecutor, hey, go get the judge, hey, jurors, do this, do that. I've instructed you to do that. I've instructed you to do by the law. Yeah, but then they have the decision. Ultimately, it's up to the jury to decide what law was broken and then what the judge goes with the sentencing. So basically the jury says this law is broken, and then sentencing is up to the judge. And so in Kentucky. And so in such cases should decide whether the statement in question was libelous and could consider truth as a defense. Section 9, again appearing in all four constitutions and originally borrowed from the Pennsylvania Constitution of 1790, recognizes the crime of seditious libel, but does liberalize it by making truth a defense and allowing the jury to decide whether the printed material in question is libelous. So truth is a defense to libel when it comes to a Kentucky jury trial. Did the question of matter, was it truthful? Was it honest? Did that actually thing happen? And if it happened, then it's acceptable. It's allowed to be put out there for freedom of speech, according to Section 9 of Kentucky's Constitution. During the 19th century, the law became much more tolerant of public criticism of government, and therefore the crime of seditious libel largely faded away. However, until 1966, Kentucky prosecutors occasionally secured convictions for an analogous common law crime of criminal libel, which is defined as the malicious publication of defamatory falsehoods calculated to disturb the peace. In 1966, the U.S. Supreme Court declared Kentucky's definition of common law criminal libel as unconstitutionally vague, which it is. It's really vague. It says just nothing. It basically just says a jury can decide what libel is, and thus in the prosecution of this crime in the Commonwealth. So the last time they prosecuted this crime of libel in Kentucky was in 1966 in the court case Ashton, like Kutcher Ashton versus Commonwealth. So ASHTON, 1966. Section 9 has seldom been litigated, especially at the appellate level. One of the rare instances of prosecution occurred in Walston versus Commonwealth in 1907, where the Kentucky Court of Appeals held that Section 9 did not invalidate the right of a trial judge in a criminal libel case to instruct the jury as to the law. So the judge is allowed to explain the law to the jury, but they aren't allowed to dictate to the jury how to organize themselves and what verdict to give.